Greetings and welcome to this week's segment of Experts of Southern Nevada. I'm your host, Greg Adamour from Encore Commercial Realty. I'm your real estate coach, and remember, I'm on your team. Each week, I'm pleased to share an expert in Southern Nevada in different fields related to real estate and economics. And today, I'm pleased to introduce Brian Lowe, an attorney who's also a probate lawyer and an estate planning lawyer. And I want to thank you for coming on the show today.
It's nice being with you, Greg.
You've been in the field, I know you're leading attorney in the field here. You've been in the practice how long?
Practicing 32 years.
32 years.
Mm-hmm.
So we're just getting started in this stuff, huh?
Just getting started.
I know you've helped a number of my clients, and you're currently helping some clients and done a very good job. I know you have ethical, the highest standards, and your staff is very, very courteous every time we've worked with them. And what's advice for most of our viewers? They're sitting at home or on the couch or they're in the family room. They're watching us and they're thinking, wow, maybe I need to update my will or my trust. How do I avoid probate? What advice do you have to the average person who's really put it off and hadn't really faced these questions?
My advice is that they plan. Mm-hmm. And when they do plan, they should go to someone who knows the area in which they want to plan. Mm-hmm. People plan their estates for many reasons. Mm-hmm. Some of those reasons may be avoidance of probate, mm-hmm. and so they'll go heavy in trust. Other times they want some judge to oversee the administration, so they'll go with a probate. Mm-hmm. When they're looking at trusts, they may be thinking in terms of asset protection, mm-hmm. Avoidance of probate, savings and taxes. Maybe there is a problem where one of their heirs would be entitled to some kind of needs-based governmental benefits that they would lose if they were to inherit. So there are just many, many reasons why people would plan, and it's not always the value of their estate. It can be reasons that are peculiar to them.
Oh, I see. So you have to sit down individually with each family and take a look at their situation. If someone were on maybe disability or has certain benefits or retirements or pensions, that may affect the overall, may have a factor on, their the outcome of settling the estate, and you wouldn't want to have an adverse effect to one of the family members. So, sitting down together and discussing the plans, I guess, is the first thing. Good planning.
Yeah, and most attorneys will generally give a free consultation when they're thinking of doing some kind of planning for estates. Mm-hmm. And so there's generally not a cost mm-hmm. for a first consultation with an attorney. And so I would admonish everyone to contact an attorney about their estates, and if they mm-hmm. haven't had their will and or trust reviewed within the last few years, to have it reviewed by an attorney. And generally those meetings have a free consultation.
So are you saying then for our viewers, all 250,000 plus the 35,000 on the hotels that are visiting in town and the millions on the internet, so they can contact your office and discuss setting up an appointment for a free brief consultation?
Correct.
Give them an idea of what they're looking at and what they should be considering.
Right, and a lot of people will call and they'll say, well, how much is a simple will? Mm-hmm. Well, we don't know what a simple will is until we've talked to the individual. If I could just quote a price, then you can go down to a stationery store mm-hmm. and get a form document.
Oh, yeah.
But if you're really interested in planning your estate, you really need to talk to someone who does this kind of planning, because they can bring up a lot of things that maybe you are not aware of, sure. and then plan it accordingly.
I'll probably be one of the first callers. I've got a living trust that needs to be updated. When you have a trust, and I think Nevada has some of the best trust laws in the United States, from what I'm told.
They do.
So asset protection is an important thing. But sometimes a father, mother, somebody may leave their heirs an estate, and 10, 15 years goes by, 2 or 3 of the children or something may have been deceased or incompetent or something. So I guess these wills, these trusts need to be updated as new laws and different things affect the the legal environment that they're in.
Sometimes new laws, sometimes just changes in the family.
Composition of
yeah.
family. Yeah.
So it is good periodically to review it with an attorney, because then they can see where changes in the law may affect them. For instance, a lot of times a husband and wife, this being the first marriage, have children. They want to provide for their children, and they don't have a large estate, but they possibly did their trust when the exemption from having to pay estate tax was down around $600,000. And so the normal way of planning that estate at that time was to have an A trust and a B trust. And by doing that, they were able to take advantage of the exemption and not have to pay tax on that exempt amount. But now, with the exempt amount being up over $5 million, most people are not involved with having to pay any kind of an estate tax. And then with another change in the law, and that's called portability, any unused exemption of one spouse can be carried over and picked up by the surviving spouse. So that exemption now can be $10 million, which does away with having to have an A trust and a B trust, or two different trusts. One of those trusts, the B trust, is generally an irrevocable trust, and really after a person dies or their spouse dies, they always think everything is now mine. But they find out that they did the trust, and there's a B trust there that has to be funded, and it's irrevocable, and now circumstances have changed and has limited their ability to make any change in that irrevocable portion.
Oh, so when did those laws change? Do you remember approximately how long ago? Because a lot of people probably aren't aware of this, and they need to update their...
2010 it started changing. The major changes started then.
Well, it seems like it's a lot more advantageous now for people. They have up to $10 million for a couple to avoid probate on, and I think that's one of the attractive things about Southern Nevada. You know, a lot of people are retiring or retiring in Las Vegas, and the baby boomers are locating here for the weather, and because of this, you know, the state taxes are so minimal. And I've told that there was no inheritance tax here, so I think up to a certain point, that's probably correct.
Yeah. Now, you know, some people come in my office and they were concerned that they wanted to avoid probate. Well, we have sometimes, as a couple gets older, one of the spouses may need some kind of long-term care, and maybe they don't have any long-term care insurance. And now they're having to pay for that long-term care themselves, and they have to use up every penny, or all but $2,000 before the government will step in and give any assistance. And so sometimes when a person does an estate plan with a trust, an older trust, what will happen is everything goes to the surviving spouse, or it stays in the same trust, whether it's an A trust or a B trust, but it's for the benefit of the surviving spouse. And so the government, Medicaid specifically, considers that an available asset and can disqualify them from getting any Medicaid assistance until it's all gone. And so nowadays, sometimes what we do is we change that trust to provide that if the spouse is in fact eligible for Medicaid or is receiving any kind of Medicaid, then instead of it being administered under the terms of the trust, it flows out of the trust into a probate. And it's just a quirk in the federal law. And the federal law will allow us, under a probate situation, to take those assets, create a trust within the probate to help that surviving spouse with all those assets. But it's not an asset that is considered an available asset. And therefore they can pass that on then to the next generation rather than having to spend it down completely.
Wow, you can see our viewers, that's worth tuning into the show right here, because normally when we get older, one or two of the spouses will have certain medical needs, and today's cost of medical attention is very expensive. And if you're getting Medicare right now, or you're eligible for it and have a wife that's disabled, you know, I wouldn't want all of my estate, if I were, you know, at the time that the Lord takes you home, you don't want to have everything going into medical bills. So just right there alone, to defer that income in a legal way, done properly through an attorney to preserve the estate. Because most of us work our lives away. We invest in real estate or stocks and bonds or precious metals, whatever it is we do for a living. We get to a point where we want to retire, then it's just ridiculous to allow those assets and that lifetime's worth of work to get squandered, and by not knowing these laws. So I think just contacting your office right there for the free consultation is just a wonderful bit of advice for our viewers to consider. I know I'll probably be making an appointment with you next week.
I'd love to have you come in. And
just a simple, checkup. Hey, what's going to happen if I die? With my wife be protected? With my sons? And what about grandchildren? And there's different people. Sometimes grandchildren are born after the will's already written, and so we need to update things to go along. You mentioned probate. For our viewers that are not familiar with the word probate, what in general is probate?
Well, probate is an administrative process where you're taking the assets of one person, the decedent, and distributing it to who he wants it to go to or his heirs, and to properly do it. It's like real estate. If you sell some real estate, you like to have the owner of the real estate there to sign the deed. But once that person dies, who can sign that deed? And so it can be just kind of held in limbo, no one being able to transfer title to that, and so it takes a court order generally, and so you go through probate and you do what the law says, and once you do that, then you can get an order of the court saying that it's going to be distributed this way, and so it now frees up those assets to be properly managed by the heirs.
Oh, how long does this process generally take?
It depends. If the total value of probatable assets, and when I say probatable assets, that does not include assets that are held in joint tenancy, or transfer on death, or pay on death, or beneficiary designation, or held in trust. All those assets are taken care of a little differently. Probate assets are those assets that do not fall under one of those ways of administering it. And if the total value of the assets, probatable assets, is under $20,000, then all you have to do is wait 40 days and sign an affidavit of entitlement, and now you can legally take over that property. If it goes over 20,000 but less than 100,000, then we can in fact petition the court to set aside the probate, and we cannot do that until 30 days have passed after the date of death, and then it takes approximately 3 weeks to complete it and get a court order. But once it goes over 100,000 in value, now you're into a probatable situation, and if it's between 100 and 200,000, the minimum time is probably around 5 months. And if it goes over 200,000, then the minimum time goes up to about 6 months, just because of the things that the legislature has said we need to do in the proper administration of an estate.
Oh, I see.
And part of that administration is it's very few of us nowadays that are going to get out of this life without some debt. And that debt may have various statutes of limitation on collection. And so an estate may have many debts, but by going through the probate administration and giving the proper notices, then that statute of limitations for creditors coming in and being able to get paid is reduced anywhere from 60 days to 90 days. So somewhere in that range. So it can really, you can walk free having gone through the administrative process, knowing that creditors are not going to be coming and knocking on your door in the middle of the night.
Yeah. Suppose like for the average viewer, maybe they've had medical expenses, some extensive medical treatments, and incurred a lot of medical bills. And so during the statutory period, whether it's 30, 60, 90 days or more, those bills get presented, I guess, against the estate.
They do.
And if they're not presented in that timely way, then I guess the statute of limitations exempts them later on.
The statute of limitations runs on their making any claim.
Mm-hmm.
And either they come into the room with us and say, yeah, I have a valid claim and I'm making that claim now, then they will be considered for payment. If they don't get into the room with us, then the door closes.
I see.
At the end of the 90 days or 60 days, and then they have no right to get paid. So it behooves, creditors to keep their eye on the legal notices, so that they know that if someone has passed away, that there's a statute of limitation that could be started.
Is there any duty on the attorneys or the courts, other than legal news and publications in a published newspaper or something? Is there any other obligation on the family of the heirs to contact the creditors?
There is. The publication of notice to creditors is a statutory period. It starts that statutory period, and that is good for all unknown creditors. But there may be creditors that have sent bills, and so they're known creditors. And so on known creditors, they have to have at least a 30-day notice before you cut them off. So if you send the actual notice, which we send out a letter saying these are your rights to get paid, and so make the claim through this office, and they will send the claim, and then they will be considered. But let's say you publish notice, the 90-day notice, you've gone out 89 days, and you didn't send the actual notice to a known creditor, you've got to give them at least 30 days, so that extends that statute of limitations on that particular creditor for 30 days.
Okay, so known creditors have at least 30 days to respond
of 30
to
days,
those.
correct.
And then I'm sure there's some reconciliation to make sure they're valid debts. There's some type of verification, because you don't know what the final medical expenses could be, hundreds of thousands of dollars.
Sure.
What about in the case our viewers are watching and they have a life insurance policy? That is that exempt from the probate? His husband leaves his wife a couple $100,000 for death benefit. That's not subject to creditors, or is it? I'm not sure.
And that's a good question. If they name a beneficiary, for instance, you name your spouse as the beneficiary, then it is not a probatable asset. It will flow to her. The proceeds, when that is paid, is not subject to the claims of the decedent's creditors, nor of the receiver's creditors. Okay? So it behooves you, once you get that life insurance proceeds, that you do not commingle it with your other assets, because if you commingle it, then the argument is it's not specifically held for what the decedent wanted it held for. And so you some life insurance companies now will, in fact, rather than send you a check for the total amount of proceeds, they will send you a checkbook and say, whenever you need to write anything against that, just write a check on this account.
Oh, that's good. Set up a new
And
account.
therefore it's always separated and is not subject to creditors.
Right. We talk about commingling. A lot of reviewers, in real estate, it's kind of a common term, and keeping accounts separate, different trust accounts for different things. Realtors, when we have property management or escrow accounts, everything's set up separately to protect the interest of that person who those funds belong to. So beneficiaries of insurance policies, you don't want to put that right into your general savings account, because if there are creditors, they can attack or attach that checking account. So it's good that insurance companies are looking out for their insurance. And I guess most of us really need to consider getting some type of life benefits or death benefits for our spouses as well, and to set it up. So obviously people spend a lifetime going through their careers. I mean, they start out in school and college and work our lives away, and then we hope to leave a little something for our kids, grandkids, or loved ones, or spouses. And without proper planning, a lot of that can really just go down a rat hole, so to speak.
It
sad,
can.
very sad.
Yes, it
and
is.
And avoidable.
And avoidable.
This is all avoidable.
Now, you know, sometimes different kinds of insurance can be very expensive, and when a person is young, paying off school debt and just trying to get started in a new job, and you know, all of the needs that they have, maybe at one time they would buy a certain type of policy, when later on they would buy a little more expensive policy that provides more for that person, but it's a little more expensive. So the insurance industry has various products that can help just about anyone that is in need of covering some contingency. Now, for me, as I've always felt that I've gotten the benefit of the life insurance that is on my life. How have I received it? Because every day when I go to work, or every night I fall asleep, I don't know whether I'm going to come home or die in the night. But I do know one thing, that my family is going to be taken care of. And I like that. So I've received some peace in my life as a result of owning life insurance. Some people do not care for life insurance, and but that's up to them. But I get some peace knowing that my family is covered.
Right, and a lot of our younger viewers, they're not thinking about it, but you can get insurance very affordable. I think when I was 30, I got a $300,000 policy or $500,000 policy, and it was like $300 or $400 a year. And what happened was, for about 20 years, I forgot I had it because they were automatically withdrawing every quarter, like $125 every quarter out of your account. And so when you get the insurance when you're real young, it stays affordable because, you know, they have actuary tables and so forth.
Yes.
But it's important not to let that expire. What happened was the bank, I changed bank accounts, and the bank that I had didn't interact with the computer system of my insurance company, so I got dropped after 20 years, not even knowing, because you forget about it, you think, oh, it's on automatic payment plan. And now the insurance is 10 times more expensive than it would have been had they not changed bank account systems, because when you have automatic withdrawals or you pay up for a year or two in advance, you know, so now you know, at my age, the insurance is very expensive, and regrettably, I let it lapse inadvertently. So a lot of our viewers, keep an eye on your banks, make sure that the insurance companies that they change, that the payment administration is set up to where you don't stop making the payments in a timely manner, or they'll cancel you, and then you'll have to pay a lot more at an older age. So,
and that's great advice, Greg.
Yeah, because it happens. Things like that happen in today's world. You really got to keep up to date. When talking about the probate process, how is it started? I mean, who initiates that?
If a person has a will, generally the person's will name who he wants to be the personal representative or executor of the estate. And so it's that person that would start the whole process. If a person does not have a will, then there is no one named as the personal representative, and within the Nevada revised statutes, it spells out the priority of people to become the personal representative. But it's the personal representative that would start the process by filing a petition in the probate court and starting the administrative process.
Okay, so they probably name one of their more competent siblings or something. What if there's a disagreement in a will? And that probably happens occasionally.
Now, when you say disagreement, what are you
someone thinks that maybe their dad promised me the boat or his gun collection. I don't know what the disagreement could be. Or the property, he said I could have it, or or maybe it could be contested. Maybe they thought at the time they made the will was incompetent. I don't know. I guess there's just sometimes I imagine there's bereavement. There's a lot of emotional things going on, and maybe someone had a different interpretation of what their decedent's intentions were.
That can become a problem because under the statute of wills, it has to be in writing because they cannot get the decedent back to question them. The only thing they have is a document, and under the statute of wills, to make sure that that document is the last will and testament, it has to be witnessed by the appropriate number of witnesses, and in this state, that's 2 individuals.
And this should be notarized?
By notarizing it, it doesn't make it less effective as a will, but what notarization does in this state is it makes it a self-proving will. So upon the death of the decedent, we don't have to go out and get those witnesses in to prove up the will.
Okay, and does all of your property, one's property, have to go through probate? And if not, can probate be avoided?
Probate can be avoided by proper planning. I mentioned some of those ways a little earlier. One, by putting assets with a pay on death or transfer on death, and even in the real estate industry, you know, the statutes now allow for someone owning a piece of property to do a transfer on death deed. So immediately upon the death of the decedent, the house is now owned by the transferee on death, which is a good thing.
The community property, right of survivorship, and joint tenancy.
Yes.
Oh, that's really good. And can probate be done without an attorney? I mean, I would not recommend doing this yourself, but I guess it could be done.
Sure. The system is set up that people have a right to an attorney, but that doesn't mean they have to have an attorney. And in most cases, and probate being one, you don't have to have an attorney to do this work. But a probate attorney, and we've got a great probate bar, by the way. We've got some great lawyers in Clark County that are good probate lawyers. But they've done it for years, and they know the law. And someone doing it themselves don't always know it. And sometimes they will get a hold of a notary or an ex-paralegal or something to help them out, and sometimes it works and sometimes it doesn't. So I have found that it's best to get some advice.
Yeah, I really think it would. And I noticed you were recognized by, was it Martindale Hubbell as one of the preeminent lawyers in your field here? You were recognized and received an award for you know, being, I guess, one of the top attorneys in this area of law. So that's congratulations for that, by the way. And I know personally you've done great work. And if people want to get a hold of you, what's the best what's your office number or your best way to get a hold of you?
Okay, my main office is here in Las Vegas. That office number is area code 702-259-0002. Again, that's 702-259-0002.
Right. Now you have Julie and a couple of people have been very courteous, very helpful to work with. I know you're handling one of our probates right now, and they were very happy with the advice you gave them a great deal of peace of mind. And we wanted to, you know, thank you in our last minute here for coming in today and sharing some of this information. And I'm sure you'll be getting some phone calls and some people who would like to get a checkup on their estate. And I know I'll be one of the first callers. And I just want to thank you for coming in. Maybe we could have you come in and share your knowledge again. Probate law, estate planning, very, very important. Don't put it off. Give Mr. Lowe a call. Brian answers his phone. I know I call him. He answers his phone every time. Brian, I want to thank you for being our guest today.
Thank you, Greg.
Sharing your knowledge. And we invite our viewers to be with us every Tuesday right here on Channel 17 at 9:30 a.m. and 5 p.m. Again, I'm your real estate coach. You can find excerpts of these segments on our website, thebestlasvegasrealtor.com. And we'll see you right here next Tuesday. Thanks for sharing with us today. Again, thanks for coming in.
Thank you, Greg.
Okay.